The Supreme Court today is facing unprecedented challenges, from rulings that impact all of government to assaults on its reputation for independence. Today's guest, Jennifer Mascott, has had a front row seat to much of it. Clerk to now 2 Supreme Court justices, testimony before 2 justice confirmation hearings, TV contributor, law school professor, and law reviews too many to mention. Mascott knows one thing for sure. The Supreme Court has never been more important nor second-guessed, and that should concern everyone. From Ballard Studios in Washington, D.C., it's 13th and Park.
We give you information, not a panic attack.
I mean, look what's going on. I mean, my God.
This was it. The kids were gonna die.
That time is gone forever.
This is the biggest story in America.
We weren't prepared for this.
Don't you want to speak truth to power?
Toughest thing I ever had to do.
Professor, welcome to the show. I hope you don't mind if I call you Jen.
Perfect.
I feel like we've known each other our whole life. I got to start with this question. You scored a 4.22 GPA when you graduated from George Washington Law School. How is that possible? You can get a 4.22. 4.0 is impressive enough, and apparently that was the highest GPA ever in the history of the school.
Well, I had some great professors, and I like to bring a little bit of intensity to life. So GW had great students, great professors. I learned a lot, and it was super fun.
I have a feeling if you just give us your 4.0 lecture, we're going to be plenty educated. But if you give us your 4.22, I know we scored something big. So anyway, let's talk about your experience. At one point in your varied career, you were clerking for Supreme Court Justice Clarence Thomas. You've also clerked for Brett Kavanaugh when he was on the U.S. District Court of Appeals in D.C. What's it like to be a law clerk for those 2 people who are doing such important things that affect so many things?
Well, I'm sure if you talked to a lot of law clerks, and thanks for the great question, they would say it's really an honor to be able to serve really in any capacity in the government. But in that particular role, the law clerk, because you're only there for a year and there are so few of them, it's a fairly intimate, close-knit community. And so it's wonderful to be able to get to know the judge and be mentored by him or her. I would say in both of those cases, by the time I clerked for Justice Thomas, he, of course, was a well-known American figure. Judge Kavanaugh was not as well-known because it was literally his first year on the bench, but he was coming right from this very fast-paced White House job as staff secretary, where you literally in that position have to review every bit of paper before it reaches the president. So he is very quick. And in both instances, it was intimidating because they're well-known, they're smart, and you're really trying to learn, because the reality of it is there's just not that much you're going to be able to add to the situation. So you want to bring humility and collegiality with your co-clerks. And I'd say I learned just as much as from my co-clerks as the judges, and have kept up with everybody over the years. And honestly, if I had to give credit where credit's due, I would say the judges and the clerk communities have really been responsible directly or indirectly for every professional opportunity I've had since that point. So I'm very grateful.
Isn't it daunting at different points, Jen, when you're working on a case on behalf of a Supreme Court justice, knowing the import that that has on just about everything and everyone?
It is a big deal. I think being in the building and some of the training and introductory sessions that you have with the Chief Justice or your justice at the beginning help to frame that. So you bring a requisite level of care. My spouse and I also did a lot to try to clear the decks from a family standpoint, because I had a baby when I was clerking, to try to focus and realize that was going to be an unusually intense year. But the reality is, the judge is the one who's taken the oath. So you can rest in the fact that you want to be concerned about their reputation and serving them. And I would have to say it's the Supreme Court clerkship so unique. Not only do you typically run all of your thoughts about the particular case by your co-clerks, but there was a lot of discussion among law clerks from the chambers. I mean, you would always keep confidentiality with what your justice said, but if it was your own musings, a lot of checking and just getting a sense of the range of sources and making sure everybody had collectively been thinking through all the issues, which I found to be very, very helpful.
Your favorite Supreme Court justice, past or present?
So you're trolling me out with this question. Since I know two current ones, I can't pick. So I'm going to go to the past, and I'm going to say several that I find intriguing are those who had multivaried government roles. So I think Justice Jackson, who was Solicitor General and Attorney General before he came to the court, and prosecuted war crimes at the end of World War II. So think about a position that had a lot of gravity there. And he was, I believe, the final Supreme Court justice not to have a law degree, if you can believe it.
Wow.
And then also Justice Taft is intriguing because he served as president and then as Supreme Court justice and wrote one of the most well-known executive power opinions of our time, Myers versus United States.
Let's get into some serious ground here. Obviously, there have been a lot of questions raised, Jen, about the integrity of the Supreme Court these days. Let me play you this clip and get your reaction.
There's an irony to the Supreme Court. Justices are not politicians. They are not elected, and they don't write laws. But they are nominated by the president and confirmed by the Senate. Politicians are aware that how they vote on Supreme Court nominees matters to voters. The justices may not be political, but the process of being chosen is.
So that's one of thousands of stories we could play and get your reaction to, but it goes to this point. More and more, it seems like Americans are starting to question whether or not the court, which was established as the unassailable third branch of government that would be beyond politics and beyond, you might say, the passions of the moment, and yet people are starting to question whether or not they're maybe succumbing somewhat to that. What is your feeling about what this court maybe needs to do, Jen, to even reestablish the very things that each of those 9 justices who sit on that court have sworn an oath to do?
Well, I thought the clip you played was spot on in a sense because it gives us a context of the constitutional role of the court and what the incentive structures were meant to be. And so as your clip points out, I mean, we're used to thinking about the independence, which is a constitutional concept, which is brought about by the fact that there's lifetime tenure and salary protection. So justices don't have to worry about retribution for their decisions. But the front end of the process is indeed political. And when we say politics, we sometimes think today quickly of corruption and all of the bad. But the political process or political accountability really is a way for the people of the United States to be represented. And so if we're not going to just have some distant elite or some oligarchy ruling the country on the Supreme Court, it's essential that elected officials have a say in picking them, and they can pick them according to the parameters. So I've never found it very persuasive, for example, when people get bent out of shape if a president says, I want to pick somebody from a particular background geographically or experientially, or however they want to pick it, because that's really their choice by design. And I think the justices, they're sometimes getting a bad rap, but they usually get a bad rap by the people who don't like their decisions. And I actually think one stark example of how this court has managed to maintain independence is the terrible norm breaking of the leak of the Dobbs opinion a couple years ago. And immediately a lot of public pressure brought to bear to find the leaker, but also on the justices. And you know what? That opinion really didn't change very much from the time it was leaked to when it was issued. They didn't respond to that pressure. I think another example is if you're talking about presidents appointing justices, President Trump, of course, appointed 3 of the justices who then had to review disputes or consider whether the court was going to hear disputes involving his election at times. And often were reaching decisions that were not as much in the political interest of President Trump as they could have been. And that seemed to me quite telling. So my personal view is on all sides, all 9 justices, I think are really trying to rule in accordance with what they believe is the constitutional legal answer. The reason we get so much difference on the court is because the justices sometimes have radically different views about the proper role of the judge and law and decision makers. But I do think they're all at that level trying to do the right thing.
How concerned are these justices today, would you say, Jen, about, call it their image? I'm in the image business, right? So, of course, I go to that question. But image breeds credibility. But do you think there's more of an awareness by the 9 justices about the fact that they're more and more seemingly under the microscope of public opinion and inspection?
Well, I hope on some level that they're not really worried about public opinion at all,
Hmm.
right? Because the whole reason they have tenure is to free them from not having to be concerned about it. It's supposed to be a backstop where if the political branches don't get it right, they can step in and make sure individual rights in concrete cases aren't violated. And
Right.
so it's essential with all the tension we sometimes have in our country that we have an independent body. The one wrinkle is I do think if you've listened to some of their confirmation, the hearing testimony. So, for example, Chief Justice Roberts, he testified about the institutional integrity of the court. So some justices more than others, I think, believe their role to be to preserve institutional integrity. So of course they want to make clear they're reaching unbiased decisions, but I don't think that translates to holding up a finger in the wind and turning based on which way the political winds are blowing.
So there are a number of cases that have been before the court and still before the court. One of them is the CFPB case. That and the Loper case, I think it's referred to as. Both of these have impacts, Jen, don't they, on the ability of government agencies to kind of hold sway when it comes to new regulations and creating and instituting policy. How important are these two cases to, you might say, government in general? And what impact could that have if the decisions go a certain way and the agencies with the Chevron deference losing ground as opposed to gaining?
Well, you're exactly right. This is a big administrative law regulatory term at the court. And so, as you mentioned, there was the litigation involving the Consumer Finance Protection Bureau. The appropriation structure for the agency is unconstitutional because the director can pull money each year from the Federal Reserve instead of having to go back to Congress. And then, as you mentioned, Chevron deference. And so, for our viewers who aren't as nerdy in the ad law space as, maybe some of us on this call, that concept is really about whose view of the law do you defer to when you're reviewing agency actions? Is it going to be the court imposing its law or its view on legal questions, or do you give the agency deference where there's ambiguity? And I think this term, the court is re-examining whether it's gone kind of awry, I think, and created some
Hmm.
doctrinal confusion in that space. And maybe instead, there are some purely legal questions that judges have to answer. But once you've given legal meaning, then you're not really deferring to the agency after that. You're just saying we're in our policy space and we have to review this under the Administrative Procedure Act. So I do anticipate the court will clear up confusion there. The final case that could have impact deals with the Securities and Exchange Commission, JARCAC. And this case and the CFPB case are coming up not because the court really wanted necessarily to hear the
Hmm.
cases, but because the Fifth Circuit, the circuit that has states like Texas, Louisiana, found big constitutional problems with the CFPB funding. And then with the SEC, they said the adjudicators here imposing penalties or violating all kinds of constitutional norms. The court at oral argument seemed persuaded about potentially the need for jury trial rights when the SEC is adjudicating fraud claims, because they look an awful lot like standard historic common law claims for which we have a constitutional right
Right.
to a jury trial. I would guess that the Supreme Court may find a problem there, but would be very narrow and tailored in terms of trying to just resolve the case before it. I wouldn't expect it to pronounce necessarily and try to get into all the other types of claims or agencies that might impact, but we'll see. The CFPB case, intriguingly, 7-2, and a majority by Justice Thomas, they found the Fifth Circuit was wrong and upheld the CFPB and said with the appropriations clause, the founders didn't give any instruction. So long as there's an appropriation, which there is here, it can be for many years. And I actually think that's another telling decision that the court's trying to get it right, because it's against what you would think some of the conservative justices' policy bottom line would be. And it also shows that they're capable of looking at a general constitutional term and not mucking around with it too much where it's not warranted. Even if they look closely at jury trial rights in another case, they're going to interpret it as it comes and as it's written.
There's now increasing focus on the First Amendment rights. I can tell you a lot of parents are very concerned about social media and its impact on kids. Where do you think that goes?
Well, I think you're right that it raises some really big questions, because social media companies like Meta, Facebook, X do have a lot of influence over the amount of time we're spending and where our children are going. And so I think this litigation, because it's brought by two state attorneys general in Florida and also Texas, are concerned that the platforms actually, in trying to regulate themselves, are potentially having freedom to make decisions that would be substantively against views or policies of these states that they don't like. The challenge, I think, for the Supreme Court is that it frames a strange First Amendment question. Normally, because the First Amendment's a right against government restriction of speech, normally you would think the claim would be, oh, Texas and Florida don't violate our First Amendment rights. US don't violate our First Amendment rights. The states to win here have to almost suggest to the court that the court treat the social media companies almost like governmental actors because they have so much power. And these cases are coming up in preliminary posture in the sense that there hasn't actually been a full-blown trial to figure out precisely what the policies are and how they're applying to the state. So if I had to guess, of course, it's always perilous to guess, but one option the court could go with is to send the cases to remand them back to the lower courts for more trial or discovery to figure out exactly how these policies are going to be applied. And to be perfectly honest with you, I don't know how they would really issue a resolution if they don't do something similar to that, because it raises so many challenging questions that can vary based on the context. And the First Amendment itself is inherently fact-driven. How much suppression is it? How are the policies being applied? I would doubt they have enough information to really come up with a far-reaching decision, unless it's going to just be to say, the First Amendment doesn't apply in this context, but that would be an awfully impactful decision to reach at a very early stage in this litigation.
So not surprisingly, if you were to Google Donald Trump and legal cases, you'd have all this stuff coming at you. And obviously there's the trial that is apparently coming close to an end in New York. But the bigger one is really the discussion about presidential immunity, where the court is trying to determine where the line is. And I got to tell you, Jen, I'm concerned, and I think probably a lot of people are, about judging presidents, especially after the fact, on things they had to do often at the moment, right? You don't have days and weeks and months to figure out what to do in like a crisis situation. You got to move. And there'll be lots of second guessing by lots of people after the fact. Is there a line that's appropriate that the court should be looking for that is reasonable in terms of its application to a president or a former president and what we hope they're able to do, which is to lead?
So that's a great question and a really interesting area. The question whether a president can be prosecuted while he's in office has been dealt with by the executive branch actually in a 2000 opinion during the Clinton administration, which perhaps unsurprisingly concluded that a president could not be prosecuted criminally, at least for acts during his time in office while he was in office. Of course, now we're post-office, but nobody brought these prosecutions against President Trump while he was president. Does it change now that he's no longer serving? If we say no and you can't ever prosecute him, does that mean a president's completely above the law? That would be
Right.
the other extreme end. The other thing that makes these cases challenging is they're brought by Jack Smith, who's in the position of what we call special counsel. He's going after President Trump. Rob Hur is another name people might know, who was a special counsel who investigated Hunter Biden. And of course, some folks were dissatisfied with the way in which his report was written. And the illustration here is that people all along the spectrum can have reason to be concerned about decisions with special counsels because it's a unique role. It's a person who's not truly accountable. They don't have to go through the typical prosecutorial process at DOJ. And so I think that's going to actually motivate the justices a bit here because they probably are coming, and you could tell from their questions, they have concerns in general about the role of a special counsel. And then here it's amplified by the fact that the special counsel is actually investigating someone who's not just a past president, but is a current political rival of the sitting president. So there are enormous constitutional questions at stake. So stay tuned on that. I think the court's opinion here could be very, very impactful for just all kinds of questions about how free an elected president's going to be in the future to carry out his role without second guessing by political rivals.
I'm not a constitutional scholar, never will be. Yeah, Brown versus Board of Education, other landmark cases where it seemed like the principle of the issue was first and foremost. In today's world, it looks like personalities, as much as policy, are front and center. The president, former President Donald Trump being a good example that theoretically and hypothetically, you think it should be about the issue itself. But separating the issue from the principles is becoming much more difficult.
It is challenging to separate the issues from the principles. I think the court is actually happily preserved from a little bit of this because they do not give live airing of their video feed. And in fact, there's no video feed, obviously. So that's one thing they're trying to do to preserve themselves. You say politics is driven by personality. I think that is true. I mean, if we find that unsettling, though, I think we have only, of course, ourselves to blame, because we're the ones deciding on what grounds we're going to vote for people and elect them. And so if we want to tamp down on that, we need to be a more informed citizenry and make decisions for the long run and not be swayed back and forth. We also need to investigate truth, I think, and look at both sides and not be afraid of the truth. And if we have a strong view, there should never be a moment where we're afraid to hear the other view, because the strong view and truth can withstand scrutiny. And so even with all the personalities, I can just tell you, as a former government servant, being in the executive branch and also served some in Congress and then, of course, clerked, never really at any time in our system, there's lots of things that are on the table. How are you going to argue this particular case? How are you going to interpret this particular law? But nobody's really sitting around contemplating flouting Supreme Court decisions, right? It's like, how will we interpret it, argue it in the future? We might even have a president issue a signing statement saying, I don't like this part of the bill. Maybe I'll consider not following it. But they want to make the decision conform to what they think it should. They're not saying, let's ignore it. And I think that's actually quite a strong statement about stability here. It's a very strong norm. And we as a system should feel grateful and I think proud that that is a norm that we have been able to sustain over hundreds of years.
So every year, Gallup does a poll on institutions across America and how popular or unpopular they are. There are only 3 institutions in the last umpteen years that are above the 50% approval line. They are small business, the police, and the military. Everything else falls below the line, including the United States Supreme Court. How do they get the moral and intellectual high ground back in the minds of the American people who are passing great judgments on them, probably most of them either misinformed or ill-informed?
I think they have to keep doing what they're doing and issuing decisions and resist the temptation to be blown about by poll numbers. And, I mean, it's just hard to evaluate. I understand why people are curious and they want to measure institutional effectiveness. But one way indeed to undermine it is to start calling people and surveying and saying, do you have disrespect for a certain institution? So sometimes I think the navel gazing at institutional integrity is itself calling into question the institutions. It's going to work its way out because this country has seen great division in the past. It's managed to survive a civil war. It's managed to survive many constitutional amendments. It's managed to survive. And I feel optimistic that the American people can sustain this country for decades and centuries to come.
Thank you for a 4.22 lecture
you're so funny.
on the Supreme Court and everything else.
You got to make sure people know that's not on a scale of 1 to 10, by the way.
Whenever you hear no one's ever done fill in the blank before, you're impressed. But it's important in a complicated thing like the law that people like you are able to articulate that in ways that people understand, because if we lose our confidence in that, I think we've lost something really big.
Well, thank you so much for providing a great tool for that through this podcast and asking such insightful questions that get to the heart of the matter.
Remember to subscribe today and hit the bell so you never miss another episode of the show with that trademark opener from Washington, D.C. It's 13th and Park.